Technically, then a speaker, the next day after a petition for disqualification is presented to him, in a day or two, he can say, I'm disqualifying you, right?
Yes.
Technically, a speaker may do that.
That he can. I tell your Lordship the reason. I give your Lordship the reason. Supposing, Malaj, the House is proceeding, a whip has been issued, and 12 people defy the whip. Just because these are live examples. 12 people defy the whip. Now, what's the need for a notice? It's on the record.
It's like contempt in the face of the court.
Exactly. It's on the record. Somebody files an application that I am seeking your removal. So under Naban area, he can't deal with it.
It has one very important bearing.
You only made
that why do you attach the disability on the speaker the moment a notice under 179C can be given? The reason is that there is no real power or restraint on the speaker in proceeding with the greatest of alacrity on the disqualification.
But on the other hand, Manoj, when there is a disqualification,
that seems to be the logic.
That's right. But on the other hand, when there is a disqualification, he has to proceed with alacrity. Otherwise, the government will be toppled. There are two issues here. What has happened today is, Malaj, somebody goes to Gujarat, goes to Assam, passes resolutions, removes people, Malaj, and that is not considered to be disqualified.
My learned brother just mentioned, if with his permission I'll share. It's not always that the speaker will act with alacrity to disqualify. In a given case, he will be sufficiently emboldened, or he may decide not to take a decision also.
That's right, Manoj. We have seen that in Goa. We have seen that in many other places.
It works. It
depends on who is in power.
Exactly.
So, Manoj, therefore,
you want to take an early decision.
Manoj, the court to lay down. It's very difficult because
very difficult then.
Very difficult. In fact, 10 schedule, each case is a history in itself. So, therefore, to formulate a principle with respect to at what time the speaker is to act and lay down as a principle is difficult, because but then legislatures and parliament has made rules with respect to when he should act.
No, but
discretion is a problem.
But
in fact, one case he will act.
The moment we are only concerned with one issue, whether at the time of issuance of notice the disqualification to preside occurs. That's the only issue we are concerned with. We're not concerned with any other issue.
Probably only answer to it is whenever at whatever point of time the case is finally decided by the speaker, it will relate back.
Yes.
If it relates back, all this is irrelevant.
No.
If it relates back, all this is because even now.
No, it won't relate.
Taking this very case, Mr.
Malaj, in the meantime,
if he decides today if your argument is to be accepted, it always relates.
Malaj, but in the meantime, a legally elected government has been toppled by virtue of the fact that the disqualification has not been decided. So, Malaj, the fruits of the poisonous tree are being enjoyed by somebody else.
I'm replying to your submission only. That it should relate back to that. I'm saying the answer.
No, that's all right. But it may relate back after 2 years, relate back after 3 years.
Relate back, because I argue in the context that your Lordship would then allow a disqualified MLA or MP to be able to do something. If it relates back, that is the person who is given the notice is himself disqualified. He can't, that is the context in which he is arguing. That your Lordship cannot then allow him to have the status of a person who can give a notice.
But the stake in this case, Eknath Shinde, who is the Chief Minister, he is the first person, he is one of the 16. How will he going to relate back? In the meantime, a government has been toppled. So, Malaj, these are very vexed questions that your Lordships will have to look at Raman Bebia and see how to answer.
Mr. Sibal, there is another aspect also of Nabam which has been worrying us. We've been in discussion, which is that ultimately in any constitutional adjudication, Nabam lays down a principle. Now, we have seen how vexed it can be, in the sense that, it really depends on the emerging political situation from case to case, state to state.
That's true.
Now, Nabam has laid down a principle which is holding the field until today.
Right.
Before we decide to enter upon this to review the correctness of Nabam, we must also be clear that it, strictly speaking, arises in a case. Now, one thing which you have to really perhaps assist us on is this. Nabam, the correctness of Nabam would arise if the speaker stood injuncted either by the High Court or by this court from exercising his powers under the 10th schedule, the Speaker was injuncted from exercising his powers under the 10th schedule until the vote for his removal was taken up.
Right.
Or he himself says that, look, in view of Nabam, I'm not going to exercise my jurisdiction.
Right.
Then somebody else may say that, well, you
Right.
have to exercise our jurisdiction. Now, in our case, what happens is that when the Speaker perhaps in that sense created a problem for himself, maybe out of the political exigency. We're not at all saying that in a pejorative sense. That's real politics. The Speaker himself gave only 2 days notice. 25th, he said, I'm going to give you time until the 27th. Our court, in the light of that, said that time to furnish your reply is extended until the 12th of July.
In the interim, Your Lordship may not have looked at that phrase.
Yeah, in the interim.
In the interim,
Now,
it is extended.
Time a trust vote takes place.
Yes.
The then government decides not to face the assembly, it resigns.
Right.
Therefore, what impact the vote or non-vote of these people who were sought to be disqualified by the Speaker would have was never tested on the floor of the House.
No, it on the 4th it was tested.
The resignation.
On the 4th it was tested.
No.
Yes.
On the resignation of the Chief Minister obviated a reference, obviated the floor test.
No,
Therefore,
it happened. It happened on the 4th.
On the 30th itself.
For Shinde it happened, the same thing.
No, but on the 30th, what happens is this. On the 30th, when the floor test is to take place, the government resigns on the 29th.
Right.
The moment, of course, they got to know that the floor test is going to be held and there's no stay by the Supreme Court. Now, as a result of that, what happens is that the consequence of the vote, which would otherwise have been cast by a person who was sought to be disqualified on the overall voting pattern, never emerges before the assembly. So, in which case, does the correctness of Nabam Rebia fall for consideration?
Yes, Manoj, I will demonstrate that immediately.
And should we go into the validity of Nabam Rebia merely because obviously very interesting constitutional issues arise? Because when we decide a constitutional issue in the absence of a factual background, that the court is trenching upon something without full facts.
Situation where it's not really a case of an anti-defection. It's a case where there is perhaps a realignment, even a starker case than this, where there is actually realignment is going on. And the Chief Minister is in an awful minority. Then, knowing the writing on the wall, the Speaker would want to declare all the others who are on the other side as violative of.
He can't unless there's a petition before him.
That's another.
Yeah.
Petition part of it is what you are saying. This application, this notice is actually not equivalent to a petition. We are on the interpretation. We are on the question of should the Speaker restrain or postpone it till some point of time. We are only on that question. In a situation like this, in order to preempt a situation, Speaker takes up the matter and immediately disqualifies them.
Let me answer that. Very important pertinent question. Let me answer that. Let's now bifurcate these two. One, you can't have a notice before a petition for disqualification. That's one part. You can only have a notice after the petition for disqualification.
Okay, that point is taken. Well,
correct?
Go to
after the notice.
The next
now, supposing there's a notice after the petition of disqualification. In that event, everything would have happened already.
Suppose there is a
the facts would have happened already, because the notice will have to be based on
a situation where a notice is there. Take a situation. Assuming for a minute that this 20 instead of 21st, it's a 20th notice. Then what will happen?
Not 20th, 24th.
No, there is a notice on 10th schedule.
Yes.
Already given by one of the minority members.
Okay.
Then what will happen?
I'll tell you, Lordship, what
then the Speaker proceeds further to disqualify all of them.
Why not? Because that's the law. That's why I said under the 10th schedule, there is no minority-majority issue. There is only a merger issue.
So therefore,
there is no defense under the 10th schedule.
About 2 days' time, he proceeds to consider the 10th schedule and immediately he passes.
But Malaj, if out of 55 or 58, 40 are on the other side, it's covered by the 10th schedule. Because there's no defense. Malaj, as your Lordship knows, under the 10th schedule, you are given only defenses. If there's a petition for disqualification, there is only a defense available. It was available, Malaj, under paragraph 3, 1/3 of the members of the legislative party, Malaj, decide to join the other. That was a defense available. We are 1/3. Right? Now, that also has gone. So there is no defense of saying, I am in majority. Your Lordship is now taking a hard fact situation that the Chief Minister has lost confidence. Actually, he's only 50 people are, out of 50, 40 are on the other side. I assume that against myself. Right? Now, Malaj, they are still subject to disqualification. So what? That's why, as I said, these majorities can't be decided in the legislature. What they'll have to do is go to the party, take over the party, throw him out, and come to the house.
There before all that time is not there. By the time they go to the party, to the election commission.
That is why this is precisely my argument.
Therefore, Mr. Sibal, your argument, I mean, stretched to its logical conclusion would mean this, that even if a chief minister of a party completely loses the confidence of his own party in the house,
Yes.
whether he has a confidence or not cannot be tested on the floor of the house.
It cannot be.
Which means that, according to, therefore, that a chief minister and a willing ally in a speaker,
the speaker will have to be with him. At least two people will have to be.
people have to be. You can support, because we are not dealing with a defection.
No, I understand.
Where you lose your own party,
But
but then you can because you have lost your own party.
I tell your Lordships, then what will happen? It's very simple, Malaj, then what will happen? Then what will happen is that under the scheduled, Malaj, the speaker will be removed. Without any other thing, Malaj. The speaker a motion will be passed or whatever, the speaker may be removed and another speaker may be installed. But that's another issue. That situation has not arisen. At the moment, we are on what? From what date does the disqualification of the speaker commence?
Important question, I'm talking.
That's all. Now, let me now read something with the Constitution itself.
Yes.
For a minute.
No, I think you've now made your submissions on the reference or the lack of reference.
Yeah. I'm sorry.
The same thing, whether the reference needs.
Right. Now, just one other. Yes, one other thing. There's a judgment of the UP Allahabad High Court, 1964 judgment, which deals with this issue, luckily.
64.
And I tell your Lordship what the judgment says. Then I give your Lordship judgment.
Yeah.
Whereas there the question arose that a chairman of the Legislative Council was sought to be removed. Now, at the time when the notice was given, he was there presiding. At the time when a motion was moved, he was still presiding. At the time when the leave was sought to be granted, he was presiding. A writ petition was filed that you could not have presided at the time when leave was granted to move the motion. Right? Leave was refused. So, Manas, the question then arose and the court said, look, under the Constitution and the rules of the Assembly, he is not required to vacate his chair when leave is sought. Because the resolution only comes up for consideration when a particular day is fixed for its consideration. So, Manas, it has to be a sitting in the Legislative Assembly, not outside, while the resolution is under consideration. So it gives you the time, the point in time.
Your point.
Yes.
Yes.
Not at the time when leave is granted, not any time earlier. While it is under consideration, the Speaker, or while any resolution for the removal of Deputy Speaker for his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every successor. That's the only embargo. So, Manas, the Constitution gives you the point in time, Manas, that he cannot preside. Now, this relates to him. There is no conflict of interest between him and third members under the 10th schedule. There is no conflict of interest. So, you can't apply the principle of conflict of interest to a proceeding under the 10th schedule where he is dealing with third parties. So the whole premise of the argument is untenable.
Got 2 points here.
Yes.
That is, while is one aspect, and other is that this talks only about himself. And
That's all my contention is. You can't make a constitutional assumption, Mother, because the whole argument has been on the premise that there's a constitutional assumption that he'll act mana fide. When Kyoto Holohan, just that paragraph of Kyoto, Mother, I'll give to your lordships, says you can't attribute to the speaker any such mana fide. That's why the provision of the 10th schedule was upheld. And just give your lordships just the page. I marked it on you. Just that paragraph I'll give to you.
You so easily vacillate from reposing such great confidence on the speaker on the one hand. Within a split second, you would again, you means, I'm saying,
I agree.
in a split second, we know how the speakers have worked.
That's true. But that is precise. That is why
these two things which go from.
That is why the minority, according to me, was right. Because only you had to only strike down that part which gives speaker the authority. The rest of the 10th schedule would be maintained. The problem is with the speaker.
That's not how things have panned out.
Those are different times.
But Malak, the point is you as a constitutional court cannot on the assumption proceed that he will act mana fide. That's the point. That's why your lordship keep on asking me what if he does this and what if he does that. That constitutional assumption you can't make. Otherwise, he should not be the authority which adjudicates.
But can we overlook the situations that have been thrown up after 92?
No, I'm not saying overlook it, Mullah. I'm the last one to say overlook it, Mullah. In fact, I'm the one to say he should not have that authority.